Now, Mr. Campbell, would you mind excuse me, giving us your full name for the record?
It's Jared Ross Campbell.
And do you wish to affirm or take an oath?
I, Jared Ross Campbell, sincerely declare and affirm that the evidence that I give in this commission shall be the truth, the whole truth, and nothing but the truth.
Thank you. Thank you. Please sit down, Mr. Campbell. Mr. Davis.
Who's the court? Who's the commission? Mr. Campbell, you've prepared a witness statement for the purpose of this hearing, have you not?
That's right.
Could I ask the operator to turn up document CRW 998 002 0803? You can see that on the screen in front of you. Is that the statement you made on the 24th of September 2021?
Yes.
Could we now turn to page, I think it's 0814. Thank you. That's, now it's showing a blank there for your signature, but can you confirm that you signed this statement?
Yes.
And on the next page, that's JC1. Can you confirm that that is a list of documents in which you refreshed your memory for making the statement?
Yes.
And then the next page after that, JC2, can you confirm that that is a list of standard operating procedures, which you refer to in paragraph 13b of your statement, which is at the top of the page 3, which will be 805.
Yes.
Now, I understand you have a change you want to make to your statement in paragraph 22. At the top of page 807.
That's right.
What's the change you wanted to make in that paragraph?
It's the spelling of the name. So John Yates should be Jon, and Yates is Yeats.
Thank you. Well, subject to that minor change, can you confirm, Mr. Campbell, that the contents of your witness statement are true and correct to the best of your knowledge and belief?
Yes, I do.
Thank you. That's Mr. Campbell, Evidence-in-Chief, and I attend his statement.
Thank you, Mr Davis. The witness statement of Jared Ross Campbell, dated the 24th of September 2021 and bearing the identifier number CRW.998.002.0803, with the change, the amendment to paragraph 22 is admitted into evidence as an exhibit. Thank you, Mr Davis. Ms Cale.
Thank you, Commissioner. Mr Campbell, you explain at paragraphs 6 to 10 of your witness statement your work history at Crown Perth. I gather from that that David Brown was the only general manager of the cage that you worked under before you yourself were appointed as the general manager of Cage and Count in March 2021.
That's right.
And that from 2007, when you were promoted to the role of shift manager, you reported directly to Mr Brown until you replaced him in March 2021. Is that right?
That's right.
Thank you. Now, at paragraph 21, page 0806, you say that you have had regular AML CTF training through what you call the Crown Learn module. So even though you've been at the Perth Casino since 1997, I assume that you're talking about a training module that's been in place at the earliest since about 2005 when Crown took over the casino.
Yes, I believe that's right.
And do you agree that as a result of that training, by 2012, you understood in the context of money laundering the concept of structuring of transactions so as to avoid the requirement to prepare a TTR?
Yes, that was part of the training, yes.
And by 2012, as a result of that training, did you understand that a patron or a third party might seek to structure payments made by the casino to the patron or third party, that is cash outs, by requesting that amounts over $10,000 be paid in multiple payments below $10,000 to avoid a TTR being raised?
Yes, across the front window location, you're right.
And you understood that if a patron or a third party to do that, that could be an indication of possible money laundering?
I'd agree with that.
And from 2012, through the training you received, you understood, didn't you, that a patron or third party, ostensibly on their behalf, might seek to structure cash deposits to the casino's bank account by way of multiple cash deposits below $10,000 to avoid a TTR?
Not to avoid a TTR, because for a patron to do that through the bank account, that would be on the responsibility of the bank receiving the cash deposits, not from the casino's point of view.
So let me just come back. I'm talking about your training.
Right.
Did you understand that if someone was to make multiple cash deposits to a bank account, the possibility would be that they were doing that to avoid a TTR being raised?
Oh, right, sorry. Yes.
And that again could be an indication of possible money laundering.
Yes.
And by 2012, as a result of your training, you understood that a patron or a third party, ostensibly on their behalf, could seek to structure deposits to the casino's bank account in the form of telegraphic transfers by way of multiple deposits below $10,000, again to avoid a TTR being raised.
Well, yes. I mean, within that program,
I can't quite hear you.
sorry,
Mr.
within that program, when you talk about the structuring side, with the program, the AML CTF training, it talks about structuring from a cash deposit and chip side of things. It wasn't a focus at the time on transfers through the account. Yeah.
So did you or did you not understand, as a result of your training by 2012, that telegraphic transfers that weren't cash deposits, didn't start off as a cash deposit in an account that was then transferred, could amount to structuring if they were all under the $10,000 limit?
Yeah, I can see that now, looking in.
But
yes.
did you see it then?
Not at the time, no.
All right. When did you first see that?
Looking back at some of the material that I've been provided, there's examples in there of 2013.
So when did you first understand that this could be an indicator of money laundering?
When you say first understand, I don't know if that's the way I would actually describe it. You know, the focus at the time, back in the cage, was around releasing funds that were actually hitting the account. And the focus at the time was looking at the transactions that are coming through and matching them with the receipts that we're receiving. I mean, that was the focus at the time.
You were looking for structuring when you were examining the bank deposits for funds to be released, weren't you?
Not back in 2013, no. No, I don't think we were.
At all?
No, it wasn't a focus at the time.
Whether they were cash deposits or not?
No.
So I think the question was, when did you become aware? Then, if it wasn't in 2013, when did that sort of penny drop?
Yeah, I'm not sure, to be honest. Like a specific date, do you mean?
Year?
Yeah. I think looking back after the inquiries that have come through, so, you know, late 19, I suppose,
Thank you.
if that's right.
Thank you,
Sorry,
Commissioner.
I missed that.
Late 19.
Thank you.
So by 2012, as a result of your AML training, you understood, didn't you, that you had a responsibility to identify suspicious transactions in the cage
Yes.
and to raise an SMR that would then be provided to the AML team?
Yes.
But if I understand what the evidence you've just given to the Commission, you would not, between 2012 and 2015, have considered that multiple deposits in the casino's bank account below $10,000 to the same patron, to the benefit of the same patron within a short period of time, was suspicious.
Not at the time. No.
And that's something that only became identifiable as suspicious to you in late 2019.
Yeah, I would say yes.
Now, can I ask you about telegraphic transfers of money deposited into the casino's bank account bank accounts between 2013 and 2015? At paragraph 43, page 0811 of your witness statement, in the first sentence, I just need to clarify something with you there. 43. Something that you've said here. You say in that first sentence that the job of preparing TT forms for the Riverbank account used to be performed by the cage manager. And then when you say when that role ended in 2013, it became the responsibility of the cage shift managers and so on. What I want to understand is this. Was there a standalone position of cage manager before about 2013-14?
Yes, there was. There was a cage manager.
Yeah. And when and did that role end so that there was not a person called the cage manager after that time?
That's right.
When there was that role of cage manager, at the same time, were there also cage shift managers?
Yes, there were.
And what was the demarcation of roles between the cage manager on the one hand and cage shift managers on the other?
The cage shift managers' responsibilities were shift-to-shift basis, and was more about the operations of the different cage locations, where the cage manager, his position would have been to oversee and more so of an administration role at the time.
Or administering what?
Things like the telegraphic transfers, staff-related issues, that side of things.
And so your point is that cage manager would prepare TTs predominantly and the cage shift managers would not?
Predominantly. The cage manager would release TTs throughout his time on shift, so he'd be 9 to 5 predominantly. So the shift managers would be responsible for any TTs that would be received after hours through the week and also on the weekend.
And why did that cage manager role end, do you know?
I think the position was made redundant.
And the administrative functions of the cage manager were absorbed by the shift managers. Is that what happened?
Yes, you're right.
And in any event, throughout the period, whether it was the cage manager or cage shift managers, between 2012 and 2015, a TT form, a telegraphic transfer release form, could only ever be prepared by a manager or higher. Is that right?
The shift manager, yes, and also the cage supervisors that worked in a higher duty capacity.
So they had to be acting in the role of a manager in order to be permitted to complete a TT form. Is that right?
That's right.
So in their normal position, a supervisor couldn't complete a TT form and a cashier could never complete a TT form.
Oh, you're right.
So obviously from the time you became a shift manager in 2007, you could prepare telegraphic transfer forms, is that right?
That's right.
And here's one from the 4th of December 2013. I'll ask you to identify, not on the public screen please, CRW.707.031.1498. So you've prepared this TT form.
Yes.
Patron number is identified underneath the patron name, and there's an amount there of $25,345. At 1499, you've attached as part of the paperwork the bank statement. And you'll see at the bottom of that page, you've asterisked and marked $6,545, and you understood that to be a cash deposit at the Bankstown Square branch?
I'm not sure about that. I can't tell from this statement whether that was a cash deposit or not.
All right, so if we go over the page to 1500. Two branch deposits, each of one of $9,550, one of $9,250. So that's three deposits all made on the 3rd of December 2013 under $10,000, and that didn't, because of your training up to that point, lead you to think there was anything suspicious about that transaction?
Looking back in, not at the time.
And accordingly, you didn't raise an SMR?
I can't tell you if I raised an SMR on that or not.
We have some separate evidence that an SMR wasn't raised.
Okay.
So you don't dispute that?
No.
Sorry, could I just ask whether it's been made clear whether it was Mr. Campbell's handwriting, the marks that were referred to?
Would you like to comment on that, Mr. Campbell?
Yeah, I can, sure. Can I just see that document again, just to make sure?
Well, it should be on the screen. I think Mr. Davis is asking about the asterisk.
I think he might be referring to the
A previous
previous
page.
pages.
That's what I thought.
So the 6545 and the asterisk.
The 6545 looks below my figures. I don't know about the asterisk, so.
Now we move to CRW.707.031.1734. Not on the public screen, please. And this is on the same day, $110,000 for a different patron. And at 1735, on the bottom half of the page, we've got an explanation of from a person within Crown Perth about the breakdown of deposits making up these amounts. You'll see different deposits at different locations, different branch locations, all on, well, within a day or two of each other.
Yes.
And your evidence is that didn't look suspicious to you at the time?
Not at the time, no.
We go to 1736. Your highlighting and handwriting?
It looks like my handwriting, yes.
And highlighting?
I would presume it is, yes.
None of that looked suspicious to you?
Back in 13, no.
All right. Now, we move on to the February 2014, and we look at CRW.707.032.1087, not on the public screens, please. There's $84,746 there that is to be the subject of a release, and if we go to page 1089, there's the supporting material that you've put behind it, all sitting just a little under that $10,000 threshold. And again, you didn't think that that was suspicious as at February 14. Is that right?
Not at the time.
Right. At February 14, had you heard any rumours or been told directly about concerns that ANZ had about the operation of the Riverbank account?
I had heard that ANZ were closing the account, yes.
And you knew why?
Yes, I did at the time, yes.
Yeah? And what did you know?
I'd heard that there were concerns around the deposits that were going into the account.
Right. And presumably you heard a little bit more than deposits, because that's what people do with bank accounts, isn't it? They make deposits. So you must have heard something about the nature of the deposits. What did you hear?
The concerns that they were under the $10,000 mark, yes.
And by the time you were processing this TT, you had heard those concerns. Is that right?
Looking at some of the information that I've viewed, then this is the fourth. I think that would be right, yes.
And still nothing suspicious in your mind?
Not at the time, no.
Well, really, Mr. Campbell? Pardon?
Said yes.
Now, we go to the email that you referred to in your witness statement at paragraph 46, page 0811, crw.529.011.1745, not on the public screen, please. And Ms Yong, in the email below, has sent an email to the Pearl Room Cage asking for an early release of funds for a patron, which funds she was confirming had been received by a money changer. And then you reply at the top of 1745, and you ask Ms Yong to instruct the money changer to deposit monies into the Burswood nominees account and not the Riverbank account. And at that point, at April, you knew that what Crown Perth was trying to do was keep that bank account, that Riverbank bank account with ANZ open, but you were aware that ANZ was wanting to close it. Is that right?
Yeah, in the email, that's how it's written, yes.
Yeah. And then you say in this first paragraph, last sentence, no doubt the money changer will distribute the $75,000 into amounts under $10,000, which is the reason for their concern. Now, Ms Yong hadn't told you that that's what the money changer wanted to do, had she?
No.
You expected that that was what the money changer wanted to do, didn't you?
The way the email's written, yes.
And that was because you had observed more than once before this transaction money changers splitting up amounts paid to them by patrons to be forwarded to Perth Casino bank accounts in amounts under $10,000. Is that right?
Having seen this email and the chain that goes with it, I'd imagine that I've commented on the actual money changer that it was, and from a historical point, that's probably why I've written it.
Because you had seen this happen before, hadn't you?
Yes, I had.
And sufficiently frequently that it had become your expectation when money changers from abroad deposited monies into the Perth Casino's bank account, they would split the money up into amounts under $10,000. That was your experience, wasn't it?
With the funds hitting the accounts, yes, it was. There's some context to that, though, in that the information we were getting from the overseas office, the management, and our international operations department, due to certain restrictions on transfers out of countries, there's limitations as to how much can be transferred at a time, which was a reason that we had been given.
But it's not a reason you accepted, was it? Because you explained here that ANZ was concerned about these amounts under $10,000, and you well knew that ANZ was perceiving a money laundering risk in relation to the splitting of funds in that way. Isn't that right?
Well, no, it's not. And like I said, based on the information that we had at the time from those departments, was reason for us to be releasing those funds.
Well, no, Mr. Campbell. If it were just the case that internationally there were limits on the amount being transferred out of countries, that wouldn't have been a cause for concern by ANZ, you would have inferred. Am I right?
Sorry, can you repeat that again?
ANZ, in your mind, would not have been closing the accounts because somebody in Indonesia or Malaysia or China, a government there was saying, well, you can't transfer amounts of more than $10,000 in one hit. You understood that very well, didn't you?
No, I don't believe I did at the time, no.
The real reason that you understood very well that ANZ was concerned was because the splitting of amounts into under $10,000 portions evidenced a clear risk of possible structuring and therefore money laundering. Isn't that the case?
No, I don't believe it to be the case, no.
So just explain to me then what you thought ANZ's concern was.
I can see what I've written, the fact that they were concerned about the under-10s. I can see that clearly. But with the lens that we were looking through at the time, when we were releasing the funds, and as I've stated with the overseas limitations that was expressed to us, at the time, I didn't see it to be an issue, no.
What was ANZ's concern about the splitting up of the amounts that you are referring to here in this email?
It's talking about the under 10, that it is under 10. Yes, I see that.
And what is the concern that ANZ had that you are referring to here?
It would be the fact that he's under 10 and a red flag, yes.
A red flag about what?
An AML issue.
Right. So you thought that ANZ thought it was an AML risk. Is that right?
I'm not saying back then, looking in now, yes, absolutely.
So back then, when you wrote on the 2nd of April that the reason for ANZ's concern is the splitting up of amounts below $10,000 into amounts below $10,000, what was the reason for the concern that you are articulating there?
As I've previously said.
Well, you can tell me again you tell me again, please.
Yeah, I was saying because they were under 10.
Yes, but
Yeah.
why did you understand that was of concern?
I raised the point out. I think that question's been put a few times now and it's been answered.
Well, I'm not sure that it's quite been answered because there was then a temporal issue where Mr. Campbell said that that's how I see it now, not then. So I think council was asking for clarification as to the then rather than the now.
I'd understood that the answer given was that the concern was that it was amounts under 10, as is written there. But
Well, if that's the witness's evidence, perhaps you can just ask him one more time, Ms. Campbell.
Just to be clear, Commissioner, what I'm getting to is that this witness has said that he understood the concern was amount
Under 10.
Under 10. The question is what he understood about why that was a concern. for
Why that
ANZ.
was a concern, what he understood was ANZ's concern
Yes.
that the monies would be split up and there'd be deposits of under 10,000 made. Can you answer this, to the best of your recollection, what you thought then, that we're talking about April 2014, about what was the underlying concern of ANZ about that issue?
We're reading this, I don't recall the email, but reading it, the fact that it is amounts under 10,000.
So I'll press a bit further, if you permit, Commissioner. It's quite clear that you're saying ANZ doesn't want amounts split up into under $10,000 quantities. What did you understand was the reason why they were concerned about that at the time?
Yeah, because it would have been a red flag at the time.
Yes. So you understood, as at April 2014, ANZ perceived this to be an AML risk.
I don't think I did, to be honest. I don't think I did at all. Based on the fact that we were releasing funds, as I stated earlier, with the information that we had at the time, there were issues with and the limitations on the monies coming out. So, you know, did it raise a red flag with me at the time? It didn't, no.
I think we can move on, Ms. Kay.
Now, I just want to ask you about another document that you referred to in your witness statement and clarify this. CRW.529.011.297.3, not on the public screen, please. You obviously CC'd your, if we go to page 2974, you CC'd your request for an early release to Cage, to Cage management, and somehow Mr. Tyler has got hold of your email and he responds in the middle of page 2973. When I say responds, you are not named as evidently one of the addressees to Mr. Tyler's email. Do you see that?
Yes.
Where he says, "Hi guys, the practice below must stop." Do you see that?
I do, yes.
Did you receive that part of the email at that time, or were you made aware of its contents?
I don't recall.
But is your evidence to this Royal Commission that you don't remember being told at around this time to stop deposits under $10,000, multiple deposits, into the Riverbank account?
No, I don't recall.
You became aware not long after this that ANZ in fact closed the Riverbank account, didn't you?
I can't remember when it was closed, no. As in the
You remember
date.
the ANZ bank account was closed for Riverbank, don't you?
I knew that, yes.
It was a big moment when that happened, wasn't it?
I don't know if it was a big moment, but no.
Well, a cause for concern in the Cage?
Yeah, look, I can't recall the actual time that it happened, no.
You remember it happening though, don't you?
Remember that it was getting closed, yes, I do.
And you were told the reason why?
Well, yeah, I must have been, according to the email, yes.
And were you told not to accept multiple cash deposits under $10,000 into the new CBA account?
I don't recall that conversation, no.
Were you told, did you cease accepting multiple deposits under $10,000 in cash to the new CBA Riverbank account?
Well, just in fairness to the witness, by the time he sees it, they've been accepted. If they've been made at a branch.
Oh, yeah. Okay.
So I just think you should be more specific, like not accepted in terms of doing what.
Were you told when the new CBA account was opened that you were not to process by way of a TT form multiple cash deposits under $10,000?
I don't recall, no.
So by the time the ANZ bank account closed, it was still the case that you didn't appreciate that multiple telegraphic transfers under $10,000 could be a structuring or AML risk. Is that right?
Yeah, looking back in, no, I don't think I did.
I can't hear you, Mr.
I said,
Campbell.
looking back in, no, I don't think I did.
And you don't recall knowing the reason why ANZ closed the account at the time they closed it?
According to the email, by reading the email, yes, I do. But I wasn't aware until I was reminded by the email.
I'm not quite sure I understand that. You're refreshing your memory from documents.
Yes.
You don't have any actual recollection of what happened around the closure of the account, the ANZ account.
No, I don't.
And you're inferring from reading the email I've just shown you that you understood the reason at the time, you understood the reason for the closure of the ANZ account.
Yes.
And you're inferring from reading that email that you understood the reason was because it was an AML risk.
Judging by what I'd wrote there, yes.
Sorry, it's just not clear to me what email is being referred to here, whether it's the email on the screen or the email that we were looking at just before, because this one on its face wasn't sent to Mr. Campbell, as the previous one was.
I'll fix it. You were referring to the document which is CRW.529.011.1745, weren't you, Mr. Campbell? It's going to come up on the screen now. That's the document you were referring to that you're refreshing your memory from.
Yes.
And do you infer from this document, as you sit here looking at it today, without any actual memory of what your state of mind was in 2014, that you appreciated there was an AML risk attached to the depositing of multiple cash amounts under $10,000 into the Riverbank account?
Sorry, I just think there's still some confusion as to the temporal aspect of that question. Whether it's an appreciation now of what he remembered back then, or whether it's what he remembered back then, or what he thinks now.
Right, just to clarify, this is...
I don't think I could have been any clearer,
No,
Commissioner, in
just-
what I just put to the witness.
Just ask the question again, please, Ms Cale.
So you don't have any actual memory of your state of mind in 2014, do you?
No.
So all you're doing when you're giving evidence is inferring what you knew at the time from the contents of the email you have in front of you in the screen. Is that right?
Yes.
And so the evidence that you have given today is to the effect, and the evidence you give right now, is that you infer from that email that as at 2 April 2014, you perceived there to be an AML risk attached to multiple cash deposits under $10,000 being made on the Riverbank account.
Yes.
Thank you. Can I ask you now about this telegraphic transfer form that you prepared in 2019? Sorry, before I go there, that evidence that you've just given, does that cause you to reconsider some evidence you gave a little earlier when you said you first appreciated the money laundering risk associated with the structuring of telegraphic transfer deposits into bank accounts in 2019? Do you infer that perhaps you actually knew that earlier in 2014 when you look at that email that's in front of you?
Yeah, having read the email, yes. As in, it's So it's jogged my memory, yes.
Now, if we go to this document again, not on the public screen, CRW.510.135.0284. So this is dated the 2nd of April 2019. TT form that you've prepared for 1.1 million Australian dollars, and at 20286 you attach an internal Crown email as part of the supporting paperwork for this transfer, which mentions that certain documents are being forwarded from a money changer in Jakarta. And if we go to, first of all, 0287 to look at one of the first documents that's provided in support of this deposit, we'll see if we'll just have to, I think, possibly even put that on its side. What looks like lots of Malaysian currency. See that?
I think it's Singapore.
Singapore currency, all right? And then at 0287, pardon? Sorry. Oh, sorry, 0292, I beg your pardon. Have another photograph of large amount of Singapore currency. Do you agree with that?
I can't be sure. Definitely the one up the top, obviously, but yeah, I don't know about the rest of that sitting there.
You're not prepared to agree that that looks like currency?
Oh, it looks like currency. I thought you meant specific Singapore.
I see.
Sure. Yes, it's currency. You're right.
And then if we go to 0300, we'll have to turn this on its side, please. You can see that by reference to the second group of data, there's a deposit for an amount of just under 300,000 Australian dollars. That's 299,985 to Riverbank Investments. See that?
Yes.
And then at 302, we see another similar amount. And then at 304, same amount again. And then at 305, an amount of just under 200,000 Australian dollars. And so you understood that this supporting documentation evidenced approximately 1.1 million Australian dollars in cash being deposited by a money changer in Jakarta to the Riverbank account. Is that right?
Yes. Yep.
And I suggest to you that at that point you must have considered the possibility that this could be money laundering.
I would have said for the Indonesian payments that similar to some of the other foreign currencies that have transactional limits, I believe they were in a similar situation. There was only certain amounts that they could send out at a time.
So this is
From
$1.1 million
changes.
in cash you're seeing here, Mr. Campbell. So irrespective of how it's broken up, just the quantity of banknotes, did it not look suspicious to you coming through an Indonesian money changer? Probably not at the time. I mean, looking in now, yes. What year was it again, sorry? It's 2019. It's only a couple of years ago, Mr.
Okay.
Campbell.
Right.
April 2019. Well, it plainly looks suspicious to anybody, doesn't it?
I can see why you would think that, yes.
Obviously, a risk, an AML risk, this transaction. You'd agree?
Yeah, it's a red flag,
Yeah.
yes.
And an obvious red flag to you as at April 2019. Do you agree?
I don't know if it was a red flag as such, like I said. Having other areas of the different countries sending in amounts at the time around, the limitations, then, to see it come through in those deposits, not necessarily, but, looking in now, yeah, I do.
Well, let's not look with hindsight, Mr. Campbell. Let's look at as at April 2019 and whether it was in multiple deposits or whether it was one deposit for $1.1 million. It was in banknotes. An obvious AML risk. Would you agree?
Yeah.
And that must have been apparent to you at the time.
I can't say. I don't recall the transaction itself.
You're not suggesting to the Royal Commission that if you had seen a transaction for a cash deposit to the Riverbank account to the value of $1.1 million back in 2019, you wouldn't have immediately thought that was an AML risk. You're not saying that, are you?
No, I'm not saying that.
And you don't recall doing anything about this particular transaction? For example, you didn't speak to anyone, Mr. Brown or anybody else, about not refunding the money? Recall doing anything like that?
I don't recall.
Or speaking to anyone about whether the patron should be refused admission to the casino?
Yeah, I don't recall.
Just in that regard, in terms of refusing admission to patrons, at paragraph 32 of your witness statement, page 0808, you say that as far as you are aware, 0808, please. A decision regarding the continued gaming activities of a patron suspected of money laundering would be made at senior management executive level. Are you speaking there as at 2019 and earlier? Or just now?
I think when I answered the statement, I was answering from, the time I wrote it. So, but, that decision would have been, 2021 all the way back. It would have been a decision that would have been or come from senior management.
All right. And who do you include within senior management executive level?
Well, obviously the executive team, which the CEO, CFO, COO, that side.
Mr. Brown, General Manager, Cage and Count?
I wouldn't consider Mr. Brown in the executive level, no.
And a decision regarding the continued gaming activities of a patron, do you mean that to include whether or not the payment of funds for gaming are to be accepted by the casino?
No, I think I've answered that question regarding if there was a decision to be made for continued gaming. It was based around that.
So prior to 2021, if you or someone in the cage were to give consideration to returning funds to a patron because the casino didn't want to accept them, who would you refer that decision to?
You would go up the chain, so you would speak to Mr. Brown. Mr. Brown would refer it up.
To whom?
Possibly the CFO at the time.
All right, now sorry, did you want to say something else?
I was just thinking, or it might have been one of the other Excel, can't remember the title, one of the gentlemen in Melbourne who was involved heavily in the international business operations.
Who was that?
Mr. Tyler.
Roland Tyler.
Yes.
Now, can I come forward to the role that you've now been appointed to, General Manager Cage and Count? In replacing Mr. Brown, did you have to apply for the position?
Yes, I did.
Was it advertised?
Yes.
Did you engage in a competitive process through interview?
There was interviews, yes.
Who interviewed you?
There was a lady from HR, John Salamone, who was the Chief Financial Officer in Melbourne, and Mr. Brown.
And were you asked any questions in that interview about your attitude or approach in respect of overseeing cage operations towards the mitigation of money laundering risk?
I can't remember the line of questioning, but I don't think that was part of it, no.
Were you asked any questions about your approach or attitude to risk management?
Look, not that I recall, no.
And do you know who was or who were the decision makers in respect of your appointment as General Manager Cage and Count?
I would have expected it to be at least Mr. Brown and John Salamone. But yeah, I'm not sure.
Did you engage directly with any of the directors of Burswood Limited prior to and in relation to your appointment as General Manager Cage and Count?
Sorry, can you repeat
Did
that?
you engage directly with any of the directors of Burswood Limited before and in relation to your appointment as General Manager?
Directors of Burswood Limited. I'm unsure who you mean, sorry.
Do you know who the directors of Burswood Limited are?
Not off the top of my head, no.
Did you engage directly with any of the directors of Crown Resorts Limited prior to and in relation to your appointment?
No.
As a result of your appointment to General Manager Cage and Count, do you sit on any Crown Perth committees, such as the Risk and Compliance Committee?
Yes.
So you sit on that committee?
Yes.
Any others?
Not that I can recall, no.
Are you on the ERCC?
No.
Now, this document, CRW.700.093.0004, is a position description for the General Manager Cage and Count dated December 2020, which Crown has provided to this Royal Commission. Just looking at the front page there, and I'm not sure if you need to have it blown up.
Please.
Can you just say, scanning that, whether that's the job description that governs your present position?
Yes, I would.
Now, you mentioned at paragraph 12, that's page 0804, second sentence, in your witness statement, that you don't have any KPIs at the moment. And you go on to say that they're still being developed. Do you know how far off completion they are?
No, I haven't had a chance to check.
Is the reason that you don't have any KPIs presently because the ones that were in place for Mr. Brown, your predecessor, have been deemed unsuitable?
Not to my knowledge, no. I was told that there was, or that they were they were being redone, but I think due to the COVID shutdowns both here in Melbourne, because my direct report, John Salamone, is based in Melbourne. So I think because of the COVID shutdowns and timeframes that, they haven't been completed.
But can't you just use Mr Brown's old KPIs?
I didn't ask that question.
Right. Now, I want to ask you about the...
Sorry, Ms. Khan.
Sorry, I was wondering if it might be appropriate for us to have a break, for the witness to have a short break at this time.
I can't read that clock.
2:59, Commissioner.
Yes, it's just turned 3 o'clock.
All right. Just 5 minutes is enough, Mr. Campbell, or do you need longer?
Yeah, that'd be great. Thanks.
5 minutes?
Yeah.
We'll come back at 3:05. Thank you, Mr. Campbell. Please sit down. Yes, Mr. Campbell.
Commissioner. Now, Mr. Campbell, what I want to ask you about now is the procedure in the cage presently under your stewardship in relation to managing money laundering risk. And if I can start with one of the SOPs that you've referred to in your witness statement, which is not for the public screen, but CRW.701.006.3732. This is the AUSTRAC reporting SOP for the cage, last updated by the looks of the footer on the 11th of August 2021. Now, has this SOP been reviewed given what has come to light in public inquiries since 2020 about the indicia of money laundering through the casino's bank accounts?
Look, I know it has been updated. But actually, at this particular point, I'm not 100% sure.
You're not sure why it's been updated?
No, or would have been due to changes, yes. Or
But changes as a result of the public inquiries since 2020?
I would say so, yes.
Have you had input into this SOP?
Not to my knowledge, no.
Do you consider it to be adequate to identify and manage the AML risk in respect of cage operations? You've read it, obviously, haven't you?
Yeah, I have, yes.
So do you consider it to be adequate to identify and manage money laundering risk in respect of cage operations?
Yes.
Now, 3733, with reference to threshold transaction reporting. You see that there, that first dash point under operating procedures? It identifies certain things that must be done in respect of transactions with a cash component of $10,000 or more, and requires the threshold transaction to be entered in psycho and designated as a threshold transaction. That's to happen at the cage, is it?
That's right.
But is the actual reporting of the threshold transaction to AUSTRAC left to the AML team?
That's right, yes.
Now, at 3734, we have a page that talks about unusual activity reporting. And this is a report, this reporting is made by a member of cage staff to the AML team staff, isn't it?
That's right.
And it's the AML team who will then prepare, if appropriate, an SMR.
That's correct.
So this unusual activity report, or UAR, replaces the SMR that the cage used to prepare. Is that right?
That's correct.
And the UAR is purely an internal document.
That's right.
So is it now left entirely up to the AML team to generate the appropriate records for reporting to AUSTRAC in accordance with Crown Perth's legal obligations?
Yes, I believe so.
Now, if we look at this unusual activity reporting procedure and compare it with an earlier procedure which the Commission's seen dated around the 2012 to 2014 period, the sorts of unusual activities that are identified here does not confine structuring examples to cash out. It expands the notion of structuring to all types of transactions. Is that deliberate?
Look, I can't be sure. I didn't write that section, but I would imagine it would have been, yes.
So, all right. So who wrote this section?
I'm not sure.
We go down to the seventh last dot point on the page, and I'll give you the opening words of it, where it says, when faced with an unusual activity matter, the cashier must alert a member of cage management. See that there?
Yes.
Is it intended that this procedure here is only to apply to transactions at the front window, or in relation to all transactions within the cage?
So it talks about the cashier must alert a member, so I would say that that is referencing front window locations, because a cashier would have, or within other jobs that they do, that wouldn't be part of what they would be viewing, so to speak.
So for other transactions not at the front window, what do people do when they are confronted with an unusual activity?
They would raise it with their supervisor, and
If you are a supervisor, who do you raise it with?
actually with the unusual activities, they have the ability now to be able to lodge them online. So I would think the cashier would discuss it with the supervisor, and that organised for them to be able to sit down and enter that unusual activity matter.
Right, but if you're a supervisor or a manager and you're, for example, preparing a TT form, and you see an unusual, you see something there you think is unusual, what do you do?
Well, you could complete the form, and
Which form are you referring to?
the unusual activity form, and submit it to AML.
And is that written down anywhere specifically about procedures that or transactions that are not specifically undertaken by cashiers at the front window, what the procedure is?
I'm not sure.
Not sure. No. All right. Now, at 3735,
Just before you leave that, could I ask the fourth, from the bottom, the fourth last bullet point, see that do not put any comment in psycho? Do you have an understanding as to why psycho would not have an indication that a UAR report had been raised?
Yes, I do. It would be if a patron was to ask for their record, then it wouldn't be stipulated on the comments.
Thank you.
and just while we're there, if we go to the bullet point immediately above that says after the transaction, the person who has determined the matter to be unusual will submit a UAR through the AML portal.
Yes.
Do I understand reading that the transaction always has to be processed, even if it's unusual, before a UAR is raised?
That's right.
So there's no capacity, if a transaction looks unusual, to just say, well, we're not going to process that, we're just going to stop it so that it doesn't actually enter as released funds into a patron account.
No, look, it depends on the transaction. As an example, if it was, say, a patron that was conducting a source of funds or triggering a source of funds for, in that instant, if they couldn't meet the requirements, then the transaction would be stopped. A UAR would still be submitted after the fact, but in that case, if the form wasn't filled out completely, it would be stopped, yes.
Or if someone came up to the front window of the main cage with a wheelbarrow full of banknotes, the cage might not accept that. They wouldn't process the transaction first and then enter a UAR into the portal.
No.
So this bullet point, this instruction in the procedure, is subject to some exceptions and some discretions, is it?
When you say exceptions,
You don't always enter the UAR after the transaction. You might not ever process the transaction.
no, there's a possibility that the transaction would be stopped, but in that case, a UAR would be done at the end of it anyway,
At the end of what?
of the actual transaction. So if a patron was refused, say, a cash buy-in or as an example, then a UAR would still be completed after the fact.
If we go to page 3735, please. This is dealing with funds transfers. (3735), thank you. Funds transfers. Now, if we go to the fifth bullet point, it says Crown does not accept cash deposits to its bank accounts. Why is that?
Because there was a memorandum came out, I think it was September last year to say that Crown will no longer accept cash deposits to our bank accounts.
So you've been told that that's what's going to happen, but do you know why Crown doesn't accept cash deposits to its bank account? What the problem with doing that is?
I think it was just to mitigate the risk
What risk?
of what has occurred in the past.
What's occurred in the past?
Well, the deposits to the bank accounts, cash deposits.
There's a risk of cash deposits to the bank account?
No, what we've experienced in the past as far as cash deposits into the accounts.
Do you mean that they've displayed the indicia of money laundering?
Pardon?
Do you mean that they have displayed the risk of money laundering?
Yeah, well, we're no longer taking the deposits, no.
Right. So the next bullet point says in terms that there's going to be no aggregation of multiple deposits to the bank account. What's the rationale for that?
Yeah, same reason. We won't be aggregating.
The effect of these prohibitions, if you will, that Perth Casino will only receive or transfer payments to or from the account of an identified patron.
That's correct.
Or, and that is when we say an identified patron, one that is identified in accordance with the standard operating procedures.
Yes.
Now, if we go to page 3736, numbered paragraph 4. So here we're talking about the daily review to be conducted by Cage Management, and there's a Cage AML report to be prepared. Do I understand correctly from this that every day someone from Cage Management will review Psycho to check all of the patron transactions for that day to see whether or not any UARs are required to be prepared?
No, the following day the Cage supervisors print off the TTR report, so the threshold transaction report, which would detail all transactions that have occurred over the 10,000 mark that have been recorded in the system, ensuring that the appropriate ID, address details, etc. are recorded.
Do I understand that this is correctly, that this is in effect a double check? Cage staff, at the point that the transaction's processed and entered into Psycho, they need to prepare a UAR if that's appropriate, and it's their primary responsibility to do that. This is a sort of a second check on that process. Is that right?
That's correct, the next day, yes.
And if we just pop numbered paragraph 4 back and look at the prefatory words where it says before these numbered paragraphs, Cage Operational Management is responsible for the following reports. Who is part of Cage Operational Management?
Cage operations is normally referred to as the shift managers and the high duty supervisors. Ultimately, it normally is a function that is performed by the Cage supervisors, which would, they are operational managers.
I'm just asking you what this means in the standard operating procedure. Who is being referred to here as Cage Operational Management?
Well, it would be the Cage management team, so supers and above, yes.
Supervisors and above.
Yes.
Now, you say at paragraph 37, page 0809 of your witness statement that the AML department receives daily reports from the Cage. Are they the cash transaction report and gaming check issued report referred to at the bottom of the text on page 3736 where we just were? I'll just go back to that. See that reporting to AUSTRAC, the cash transaction report and gaming cheque issued report?
Yes,
Are they what the cage provides to the AML team every day?
that's right.
All right. Now I want to ask you about the current SOP for telegraphic transfers, not on the public screen, please. CRW.701.006.3741. This was last updated, if we look at the footer, just a few days ago on the 23rd of September. And have you had input into the revisions for this SOP?
Yes, I believe I did.
What sort of input did you have?
It was to do with the section on patron's full name and patron number to be recorded on the statement, which was missing there a comment for notwithstanding any character limitations by the banking platform being used.
And who else has had contribution to this document?
Do you mean recently or?
Yes.
There's been changes around the TTs of such, so they've been updated quite a bit from, I would say, March through to now, to present.
By whom?
Could have been myself, the lady that's listed there, and Putty Cohen. And if a direction was from, myself, then, maybe one of the cage shift managers as well.
You're not sure?
Not recently, no. As in the last 6 months, no.
All right. Now, at page 3743, second bullet point. Oh, sorry, down in the second half of the page, I meant to say. Pop that back out and bring out the processing of TT release paperwork. It appears to be a new step here in the second dot point of having two senior members of the cage management team sign the TT form to confirm that certain requirements have been checked before the funds are released. See that?
Yes.
What is meant by senior member of cage management?
Senior members would mean a cage shift manager or a higher duties supervisor that performs in the role.
Or you?
Possibly me, yes.
Yeah. And is it likely that on every shift at every cage there'll be two senior members available to sign TT releases if necessary?
Not in all cages, no. There's only usually one shift manager and one high duties supervisor on at any given time.
Over at 3744 at the top of the page, you'll see there the second and third, the second and third dash points. There's to be no aggregation of funds and cash deposits are not accepted. That is to address AML risk, is it?
Yes, it would be.
And at the bottom of 3745, there's now a provision for the return of funds. And there isn't actually a return of funds SOP in place yet, is there?
No, it's been drafted. It is almost ready to go, and I believe the policy has almost been signed off.
Right, now if we go to 3746, have you been involved in preparing that return of funds policy?
Yes, I have.
Sorry, SOP, you have.
SOP, well, yeah, partly yes.
Who else has been involved in that?
And Putty Cohen.
Now at 3746, you've got this return of funds transfer, rejecting funds. Do you see that?
Yes.
And consistent with the previous SOP, there's only payments are only going to be accepted from the personal bank account of a patron. And it says when a patron's deposit to the account doesn't meet the requirements as it might be from a third-party company, etc., then the funds are to be rejected using the following process. And there's a mention there that the patron will be contacted by their host or cage management to advise them that the payment will be rejected. But presumably before that occurs, the inconsistency with Crown's procedures or policies and needs to be identified, and a decision needs to be made that the funds are going to be returned. Is that right?
Yes.
So who makes that decision?
That would be part of the cage management's role.
Well, do you know whose role it is?
The shift manager that's releasing the funds. If they have a question, they could reference me, but it would be a discussion depending on what it was being returned for.
And there's it also specifies that there needs to be a number of email notifications made internally to Finance, AML and some other teams.
Mm-hmm.
Who carries out that email notification?
The shift manager or the high duty supervisor on at the time.
And is that likely to be something set out in the return to funds SOP?
Yes.
Which presumably would need to be read closely with this SOP, is that right?
That's right, yes.
They'd overlap to a degree, would they?
Yes.
Right. And at the bottom of 3747, just want to ask you about a notation there, at the bottom there, that says these SOPs are to be read in conjunction with the internal controls.
Mm-hmm.
Cage shift manager or above has the right to override these SOPs but must not breach any of the internal controls. There's actually a similar notation at the end of the AUSTRAC SOP that I referred you to a moment ago. Is this notation at the bottom of all of the SOPs?
I believe it is, yes.
Yeah. What are the internal controls that are mentioned there?
The internal controls are the documents that we've submitted to the GWC to inform them how we go about our operations.
And do cage staff have ready access to those internal controls?
Yes, they do.
And how do they have access to those?
It's via the intranet on all the desktops within the cage.
Now, this right to override the SOPs that the cage shift manager has, is that at any time for any reason, or are there certain circumstances that operate to dictate when the SOPs may be departed from?
Sorry, can you repeat that question?
Well, it's saying here that the cage shift manager or above has a right to override the SOPs. And so is that just like they don't have to follow the SOPs if they don't want to, as long as they don't breach internal controls? Or are there certain situations that apply for them to be able to depart from the SOPs?
Sure. No, I think they can deviate from the SOP if required, but like it states, they can't breach an internal control.
Yeah, but you just said if required. What might be a requirement to depart from an SOP?
Just trying to think of a personal example. I can't think of one, to be honest.
Now, I want to ask you about another document that you've referred to in your witness statement called, you've described it in your annexure as the Cage Cashier AML Training Cheat Sheet, CRW.701.005.5692, not on the public screen, please. Now, have you prepared this document?
No.
All right. Do you know who has?
No.
Is this intended as a summary of relevant SOPs and policies to guide cage staff when they're processing transactions to identify things they have to do to mitigate money laundering risks?
Yeah, I believe so, yes.
And is the idea behind this cheat sheet so that cage staff on a day-to-day basis don't have to wade through several overlapping SOPs to work out what they should be doing with each transaction?
I can't be sure, but I'm thinking it was possibly constructed for training regarding cashiers.
So it's not something that applies on a day-to-day.
I mean, it is within the SOP, so the cashiers have access to that, or everybody has access to that, and it is, taken off the AML policy.
So is the intention that people use this on a day-to-day basis in their jobs or not?
Oh, they can, yeah, absolutely. But I think it was actually constructed at the start for the supervisors to conduct the AML training for the cashiers.
Because the one thing that is, one thing that is notable about JC2, the annexure to your witness statement with the policies, the SOPs that you've attached to it in cheat sheets and other documents, is that there's about 50 of them that are potentially applicable to performing the work in the cage. So have you given thought to how you might refine the information to make it accessible or more accessible to cage staff so that they know exactly what they have to do in accordance with procedure?
Yes, it would be something I'll be looking at going forward, yes.
Was it something you've already thought about?
Since I've taken over in March, it's been a very busy period. There's been a lot going on, so I actually haven't had a chance at this stage, but it is something that I'll be looking at going forward, yes.
Coming back to I'll just call it a cheat sheet as a shorthand term. Bring that back up on the screen, please. Is it only intended to deal with transactions at the front window of the cage?
It would be, if more designed for the cashiers, then yes, it would have been.
And is this the only cheat sheet or checklist that's in existence, or are there many of them or a few of them?
There's a few that cross different subjects, but as far as the AML side goes, no, that is the only one that I'm aware of.
Right. And is there one for telegraphic transfers?
There's checklists, yes.
Right. So with the idea of there being other checklists and cheat sheets, if we go back to JC2, which is at page 816 of your witness statement, this is, you don't intend this to be a comprehensive list of all the SOPs, policies, checklists and cheat sheets that are available to cage staff. This is not every single document.
I don't know if it's every single, but it would go close.
Well, you're not sure whether it's comprehensive or not.
I can't be sure if it includes all the SOPs, no.
If we come back to the cheat sheet, please, at numbered paragraph 6. It's talking about the preparation of a UAR, and it doesn't appear on my reading to be specific about who actually may and who may not prepare a UAR. Is there a reason for that?
No, I don't think there's a reason for it.
And it doesn't appear to mention anything about not accepting cash deposits, third-party deposits or deposits from money remitters or money changers. Is there a reason that it doesn't deal with that?
Sorry, can you just show me the top of the document again? Yeah, as I said, I'm sure that was originally designed to take the cashiers through their training or their 3 months probationary training. So as far as a third-party deposit, they wouldn't experience that as a cashier.
What about cash deposits?
No, they would see. Oh, actually, no, they wouldn't experience that either, because that'd be cash deposits to the bank account. That would only be the management team.
Not cash at the window.
Yeah, I mean, they can get a cash deposit at the window, yes.
But are they allowed to accept that or not?
They are, yes.
I see. Now, can I ask you at paragraph 18D of your witness statement, page 0806, you mentioned that there is a role of cage financial integrity within the cage. This is a new role, isn't it?
That's right, yes.
When was it introduced?
We've just been given approval from the GWC, I think it was last week. So it will be advertised shortly.
I see. And are there any particular qualifications or experience that the person has to have to occupy this role?
There is. We'll be looking at somebody that preferably has cage experience, so that they understand the intricacies and what transpires within the cage. And also some managerial experience as well, or supervisory experience. Yes.
Anything else?
Somebody that can obviously lead the position and input the strategies and processes that will fine tune the area of risk within the cage. So the different aspects of what we do.
How do the administrative duties relating to AML that new role has intersect with the AML responsibilities that cage staff have when they're processing transactions?
Yeah, I think part of this was to do with the TTR transaction side of it. So obviously the supervisors will still do that reporting side in the morning, but rather than it be sent to the AML team to then upload to AUSTRAC, that is going to be part of the role to actually then go in, have a look through another lens, and then it will be the responsibility of the integrity manager to be uploading that information to AUSTRAC.
To report directly to AUSTRAC?
For the TTR side of things, yes.
So how does that intersect with the AML team's work?
They won't be required to do that part of the upload. I'm sure they're going to have oversight of it. The role will be done from the cage.
Will that prompt another SOP?
Possibly.
I can ask you about paragraph 24 of your witness statement, page 0807. So, second sentence, with the change of leadership in the cage, it gave us an opportunity to review operational effectiveness and culture. The change of leadership you're referring there is from Mr. Brown to you, is it?
Yes, that's right.
And in terms of a review of culture, do you say that the culture of the cage operation has now changed?
I'm not saying that, but I think the idea, it was actually sponsored by Mr. Bossy and Mr. Khan, and the idea was to take the key findings out of the inquiries and also the reviews that have taken place, to look at the structures and processes within the cage, and look at the culture and make sure that we have the tools and the processes and the systems to be able to remain compliant and etc.
Have you, as General Manager of Cage and Count, endeavoured to implement a cultural change within the cage since you commenced in your position?
Well, I suppose from my own or since taking up the position, I haven't done anything at this stage, no. Purely from a time factor at the moment, but definitely something that we're looking at within this program.
Are you satisfied with the culture in the cage presently?
Yeah, I really haven't had time to think about it, but looking in from having taken over, satisfied, yeah, I would say I am satisfied, yes.
And it hasn't changed, I think you gave evidence a moment ago, since Mr Brown was in charge. So you're happy with the culture of the cage as it has always been, even under Mr Brown's leadership? Do I understand your evidence correctly?
I'm not sure I was implying that, but yeah, I mean, there's been no major change at this stage, no.
Were you satisfied with the culture of the cage under Mr Brown's leadership?
At the time, yes.
And looking back now, do you think the culture was appropriate then?
Yeah, to a degree, yes.
So you don't really see need for cultural change within the cage?
Oh, I'm not saying that.
You do see the need for cultural change within the cage?
I think, there's opportunity for change, yes, absolutely.
What kind of change?
I think with the new processes and procedures that are coming out across what we've been looking at, and what we'll be discussing in the pilot project too, about and around processes, in that, explaining to staff that, in the past there was a lot of focus on the patrons and, transactions being done, in a hurry, whereas now I think the focus is about explaining to the staff that when we're looking at, I'll give you an example, a source of funds form again, it's not about, getting the patron sorted with their funds so that they can then go and start gaming. It's about, saying that, this is going to take time. It's okay for that time for the staff to come together, the different departments, to discuss whatever's going on with this transaction, to come up with a decision to, provide the patrons with, in this example, funds as such. So yes, there is a shift from that perspective, yes.
Have you seen any of the Deloitte's reports prepared in respect of cultural surveys undertaken within the Crown Group?
Yes, I have.
Have you seen this report most recently provided to the Royal Commission, CRW.701.006.3776? Dated September 2021 with property-specific results. Have you seen this?
I haven't had a chance to read that, no.
You've not read it at all?
No.
Has anyone brought any of the contents to your attention?
There was a meeting about it the other day, yeah.
Were there any takeaways from that meeting for you in relation to the culture of the cage and count?
I don't think it actually touched on specifics for the different areas, no.
Let's go to page 3797. Just need to put that in landscape, thank you, and blow it up. This is one of the tables that compiles the survey results. And you'll see for Perth, different business units, it's actually got the cage and count there as the first column.
Yes,
You've not seen any of this data.
I haven't, no.
And if you look at, can you see down the left-hand side, given different numbers? They're not in numerical order, so it's a little bit of a trick, but you could probably pick up item 9. These are relative agreement or disagreement with questions that people, or propositions that have been put to people to respond to by way of survey.
Sure.
Did you fill out one of these surveys?
Yeah, I believe I did.
Yeah. So the proposition is, I'm confident I will not be penalised for raising concerns. Not quite sure how you read the whether it's agreement or disagreement, but 51% of the cage and count who responded to the survey either agreed or disagreed that they were confident they'd not be penalised for raising concerns. So whichever way you look at it, there's a goodly percentage, Mr. Campbell, who think the opposite.
Yeah, I'd agree with that.
And if we look at item 11, the people I work with challenge each other constructively if they think they are not doing the right thing. It's a similar position. You'd accept, wouldn't you, that it's integral to adequately identifying and managing the risks of the cage operations, including money laundering risks, that staff are comfortable and confident to raise any concerns they have?
Absolutely.
So would you agree that it looks from this as if there's a bit of work to be done to bring all of the cage staff along to the position where they are comfortable to raise concerns?
Absolutely.
And in terms of compliance, do you see under item 13, the people I work with bend the rules when it suits them?
I can see that.
Yeah. Now, depending which way you read it, and I reiterate, I'm not quite sure how you're supposed to read it. It's either 41% or 59% of the cage and count staff who answered the survey were of the view that the people they work with bend the rules when it suits them.
Yeah,
You'd agree, wouldn't you, that percentage is far too high, whichever one it is, if risk is to be adequately identified and managed?
I agree. It's hard to read, but yeah, I would agree with that statement, yes.
So work has to be done there.
Absolutely.
Right. And if we go to page 3798, at item 22, can you pick that up? The people I work with display open and honest two-way communication.
I can see that.
Yeah. So you've sort of got either 45% or 55% thinking that there is disagreeing with that proposition.
Yeah, I can see that.
Does that cause you some concern to see that?
Yeah, it does.
Yeah. And is there anything particular that's being done within Cage and Count to address that issue at the moment, that cultural issue?
We are working through it at the moment, property-wide.
And if we go to page 3799, item 35, the people I work with demonstrate honest behaviour. It's either going to be roughly 70% who demonstrate agree that people demonstrate honest behaviour, or 30% that agree that people demonstrate honest behaviour. But even if it's the 70%, there's still 30% that you need to be worried about. Would you agree?
Absolutely.
So if we come back to your witness statement, while you say at paragraph 59, page 0813, that having Mr Bossy at the helm of Crown Perth has been positive and he has been leading the change in culture, you would agree with me, wouldn't you, that there is still a long way to go in relation to the cage and count culture?
Looking at those figures, yes, yeah, I would.
Nothing further, Commissioner.
Thank you, Ms Cale. I'm not sure if we have council in remote locations who would like to apply for leave. No? Okay, we can't hear you, Ms Boris.
I'm very sorry, Commissioner. Can you hear me better now?
Yes, I can.
I don't seek leave. Thank you.
Okay, thank you very much. Are there any applications from this room? Mr Dharmananda.
Commissioner, I don't make an application, but I do note that there would be some matters that I would ask questions of this witness in relation to matters concerning remediation. But you'll recall, Commissioner, you yourself directed that we would deal with matters concerning remediation in the fourth phase of the inquiry. So other than to observe that, for example, that Deloitte survey was undertaken in May, and there is a guide as to how to read the colouring and the percentages, and that's at page 3780 that assists the commissioners. Just place a marker with respect to dealing with those aspects of this witness's evidence as it pertains to remediation.
Mr Dharmananda, I think it's highly unlikely that we would call Mr Campbell back during
Yes.
the last block of hearing, so
It's probably likely that there will be another witness to whom some of these questions to which the witness was directed this afternoon could also be explored.
all right. But so I would allow you to ask questions of Mr Campbell if you thought that it was necessary.
Well, we were proceeding on the basis that matters pertaining to remediation would be in phase 4. So there'd be some material that we would wish to introduce in relation
Well,
to...
if you feel that you haven't had the opportunity, you can raise it with us at the time.
Yes, thank you, Commissioner.
Nothing from the Commissioner Jenkins.
Yes, thank you. Prior to 2020, did anyone in the cage daily inspect the bank statements of Perth Casino bank accounts?
Yes, yeah, the cage shift managers would have been looking at the account to see what funds were coming in, yes.
And that was, or at least one of the purposes was then to decide whether they needed to do a TT.
That's right, yes.
Can I just ask for some clarification in respect of the transaction that you were taken to, which is CRW.510.135.0284. I think this was just on, was not to be placed on the private screen. Was not to be placed on the public screens. So if we look at the first page, this is a deposit that has been made to the credit of a junket operator, Sui Choi C. Is that right? Can you tell me at the bottom of the page what it says, the redemption? What does redemption mean?
So those funds would have been going towards an outstanding debt from the patron or from the operator.
Of the junket operator.
That's
so
right.
He's he has operated a junket. He was given credit by the casino to operate the junket, and he's now repaying the credit
Yes.
the loan in effect he was given. And then what do the two lines underneath that say?
Funds transferred from Nenny by staff member Norman.
So who is Nenny?
Nenny was a money remitter in Indonesia.
And Norman was a staff member of Nenny, is that right?
That's right.
So can we then go to the next page? Sorry, it's not the next page. Yes, that is the page I wanted. Now, this is from a staff member, an email from a staff member in Crown Hong Kong's office, is that right?
Yes.
So what they're advising is that they've received some documents which are attached from the money changer. Is that Nenny, the money changer?
That's correct, yes.
And that money changer, as you've said, is in Jakarta.
That's right.
What does he or she mean when they say called to advise that he bought this fund for beneficiary of Swee Si Choi Junket?
Yeah, I'm not sure, to be honest. I imagine it is him saying that that patron that's listed has purchased the funds. That's how I read it.
You can't explain that
I see what you're saying.
in
Is that
layperson's terms any further?
no? Sorry. Are you referring to the part that's in brackets where it says the C-Suite Choi Junket that the fund is for gaming purpose?
Perhaps we'll leave that there, but can I focus now on something else? So you've got a Malaysian junket operator using an Indonesian money changer, and they've sent to Crown Hong Kong photographs of the cash which they're going to deposit into the Riverbank account. Is that right?
I'm not sure what account it went into. No.
Sorry?
I said I'm not sure what account it went into.
Well, if you go on to the next pages, please, you can see.
Yeah, I'm sorry, I'm not disputing, but yeah.
0300.
You'll be able to see that it goes into the.
0300, I think, Commissioner.
Thank you. Yes, if we turn that around, that's the deposit of some of the funds you'll see there into the Riverbank Investments
Yes.
Proprietary Limited account.
Yeah.
And the photograph of the money we saw, at least some of it's in Singapore dollars. So when you looked at this transaction, did you have any understanding as to why the junket operator in Malaysia would be using an Indonesian money changer to deposit gaming money into the Riverbank account?
I don't actually recall the transaction, but it's a good point.
Would you have any understanding now as to why that would be the case?
Not thinking it through logically, no.
The other question I wanted to ask you about that was that the Commission's heard evidence that the Riverbank account was opened to give patrons the ability to deposit monies into an account which didn't reveal that the account was for gaming purposes. Why would a money changer or a junket operator want to use the Riverbank account?
I'm not sure.
what legitimate reason would they have to want to disguise their money being deposited into a gaming account? That you can think of. I know that I'm not saying that you're an expert on this area. I'm just wondering, because you're someone who works in the area, whether you might understand that they would have a legitimate reason.
No, I can only think that the C-suite Choi Junket would operate or have operated with us for a long time, and it might have been a historical thing for them.
In respect to Norman, looking at the Riverbank account transactions, which are attached also to this TT, I wanted to know, is Norman, did Norman only make deposits into the Riverbank account on behalf of junket operator Swee Choi C, or did this money changer make deposits on behalf of other junket operators or patrons? Do you recall?
I believe Norman was a staff member of Nenny, so it wouldn't have just been this particular transaction. If funds were coming from Nenny, it's likely that he's deposited before.
So what I'm really asking is Nenny, who he's making deposits on behalf of, did Nenny only make deposits on behalf of Swee Choi C, junket operator, or did Nenny also operate on behalf of other patrons and junkets?
Other patrons and junkets.
Thank you. I don't have any
I
more
have no questions. Anything arising, Ms. Cale? Mr. Davis, do you wish to re-examine?
Yes, thank you. Mr. Campbell, you were asked a number of questions about what you knew about structuring as an AML risk in early 2014. You recall that?
I do, yes.
And you answered some questions about what you inferred from emails around that time. Remember?
Yes.
Can I ask, what do you understand by the word infer?
For what I inferred at the time.
Yes.
So
What you infer from the emails that you wrote at the time.
So my understanding at the time.
So when you were asked what you infer from the emails, you were trying to say what you understood at the time?
Yeah, well, what I understood, yes.
Now, you said at one point that you have no independent recollection of events, of the emails themselves and the transactions that those emails relate to. Is that right?
That's right.
You also said that you were aware in early 2014 of limits on amounts of transfers from overseas countries at that time.
That's right.
So do you remember being aware of those, of limits?
Would have dated back before 14.
So do you remember if you were aware of those, if you understood there were those limits of below 10,000 at around that time in 2014?
Sorry, can you repeat that again?
You said you were aware of it before 2014. So does that mean you continue to be aware of it understand that to be the case in 2014?
Sorry, I thought you were referring to the cash or the foreign transfer limit.
Yes.
Oh,
That's
right,
what,
sorry.
I may be doing that a bit clumsily. That
No,
was
no,
what I was
no,
trying
that's
to
fine.
pick up on.
Yeah, no, well, I would have been privy to that prior to 14, yes.
And do you continue to understand that in 2014?
Yes.
You also said that you only, or to the effect that you said you only came to know about structuring transactions, so into amounts less than 10,000, as being a money laundering risk, and you came to know that in late 2019, as I recall. You only came to understand that splitting of transactions into amounts under 10,000 was a money laundering risk in late 2019.
Yeah.
Okay. So, based on that, isn't it the case that in 2014 you didn't understand or appreciate that structuring or splitting transactions into amounts of less than 10,000 was a money laundering risk? No, as in you didn't understand that to be the case. So you agree with me that you didn't understand?
Sorry, can you
Yeah.
repeat the question?
Based on what we've said there, is it, or what you've agreed to there, is it not the case, isn't it the case then that in 2014 you didn't understand that structuring, splitting transactions into less than $10,000 amounts was associated with money laundering?
I think I said that it was the focus at the time, back in the time, was to do with the front window locations. It wasn't about looking at structuring from the bank account perspective, no.
So you didn't understand then, what you're saying is that in 2014 you didn't understand or appreciate that splitting of amounts below 10,000 into bank accounts rather than in cash at the front window was associated with money laundering?
No, it wasn't something that we were looking at, no.
All right. Were you ever told to ignore money laundering risks?
No.
Thank you, I have nothing further.
Thank you, Mr. Davis. Mr. Campbell, thank you very much for your evidence. Just in case there's tidying up to be done, we will leave the summons in place, but for the time being, you're free to resume your normal activities, and thank you once again, and we will now adjourn to 10 a.m. tomorrow morning.